So you're charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Shh. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 5th, 2025, the officer responded to a suspicious person with a weapon on 5900 Gulf Freeway. The officer made contact with the defendant, who was 17 years old. The defendant advised he was inside Jack in a Box while brothers were selling waters outside. The defendant saw a male rushing at his brothers with a knife, pulled out his gun, and pointed it at the male while telling his brothers to run. The officer performed a search on the defendant, locating a 9mm Glock 19, and the defendant advised he bought the gun from a friend for $150.
I mean,
Yes, Judge. In this case, the officer was going off the fact that he performed the search because he indicated there was a firearm. So
he's going to the defense of others.
Yes, Judge.
It's another person.
And it's just the way that this is pled is because he's underage. He's below the age of 21. That's the way it's pled, Your Honor.
You hear this?
Hold on, I'm gonna go yell at somebody. Hold on. Don't know what's going on. Hi, Judge. Is this young man charged with unlawful carrying of possession for being under 21?
Correct.
Hold on, I've got a kit. Here's the GPS
But I'm
memo.
more concerned about the defense of others. Did you hear it? I mean,
Well, hold on.
a second.
Here's GPS.
Let me give you a lawyer, Mr.
Yeah. Oh, I volunteer representation. Yeah,
Give me a record, can you fill that out, please?
I will do that. But here's a GPS memo saying that it's
on a second.
unconstitutional.
You know, representative gentleman?
Oh, hell yes. Here's the Fifth Circuit saying that it's unconstitutional. Here is the United States District Court, Northern District, saying it's unconstitutional. Here's a motion to quash information. I'll just cross out the name.
Great job.
Yeah, I had to get in this fight yesterday and I'm teed up.
Here you go, Mr. Tito.
Thank you.
Judge.
I was gonna, yeah, look, you gotta be very careful. You know, God forbid something happens where you really dig yourself a hole. I'm gonna find no probable cause, but really, you have to be very careful. You know, sometimes you make a decision in life and it can really have consequences, all right? You know what that means, right? Are you in school? It all starts with school, man. You got to get back into school. This is not a good way to go through life at 17. The more schooling you have, the more money you're going to make. Knowledge is power, my friend. Do it. Make something. Make me proud. Please. It's going to get dismissed. Be careful, friend.
Yeah. Literally have all that on because I have a case in another court.
I was going to find no PC anyways. So.
Right now.
There's nothing for you out there. Let me express my extreme disappointment that you've now picked up a fourth case. Cannot tell you how disappointed I am. With us, in October, terroristic threat. 2 weeks later, another terroristic threat. 2 months later, a reckless driving. And now you've picked up a felony evading in a motor vehicle. Can you tell me what happened in the latest case, please?
The evading, Your Honor?
Please.
Yes, Judge. So in the evading, it was on February 7th, 2025, and the officers observed a vehicle driving recklessly on Mason Road and initiated a traffic stop. The vehicle proceeded to drive at a faster rate of speed and changed lanes when unsafe through moderate traffic, endangering other drivers. The vehicle evaded for approximately half a mile and ultimately entered a parking lot and parked the vehicle behind a restaurant on Mason Road. And at that point, the black male wearing a bright orange shirt exited the vehicle to the driver's door and ran through a large tree bush and evaded on foot. And it looks like he continued to evade and he was approached as he ran on foot, moving across all lanes of traffic, ultimately coming to a stop due to him slipping and falling. So after evading for half a mile, he just ran on foot, Your Honor.
Judge, I know that that's not our case down here. My assumption, this is a broad assumption, is that perhaps given Mr. Jenkins's recent run-ins with the law, maybe those cops are familiar with him in that area. I don't know, it didn't articulate how he drove recklessly for the initial stop, but I think Mr. Jenkins maybe has some, I think he expressed to me that he thinks he's being treated unfairly.
Yeah.
So I don't think he was doing this out of his own safety.
You now have a fourth open case. You know, sometimes we have to protect people from themselves because they are their own worst enemy. I think that you're a danger to the public. You refuse to comply with bond conditions. You have a reckless driving with us. You were ordered not to drive recklessly, and now you've picked up and evading in a motor vehicle. I don't know what to tell you, but Mr. Jenkins, I'm now going to revoke the bond on all the cases, and I'm going to set them high because you are a danger to my public. And I've told you over and over and over and over, if you endanger my public, there's only one thing I'm going to do. So now I'm going to set each of your bonds at 10,004. I am now taking away your privilege to drive. You will be signing an affidavit with me today promising me you're not going to drive, Mr. Jenkins. And I'm going to tell you that if I find, because I don't know if you're going to bond out, you know, your now bonds are going to set up at about $40,000. So if you do bond out, you're going to be signing an affidavit with me today promising me you're not going to drive. If I find that you drive, and I'm also going to put a weapon on here, if I find that you're in possession of a weapon, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
I'm also going to order you to have a curfew of 7 p.m. to 7 a.m. We have resources here. We have all kinds of things to give to people. Cell phones, tablets, places to live, food to eat. All you have to do is ask, and we can give you things. But now you've repeatedly shown me that you're going to do whatever you want to do. To hell with any conditions that a judge puts on you. That's what you have effectively told me by picking up a fourth case and a felony case at that. So what you tell me now goes in one ear, goes out the other ear. I just can't. The unfortunate part is that these felony cases take a very long time to resolve. And I guess we'll track it. It looks like the felony is set for March 20th. If you want the next day, I'm happy to do it.
Well,
Whatever you would like to do.
See what's the chance of going, I don't want to put them in custody. If there's some resolutions that we can work on. I think on one of them was against the brother. The other one, we're waiting on some surveillance that may have come in already.
Okay. Well, take your time, whatever you want. But as it stands now, you're too dangerous for me, Mr. Jenkins. You scare me. So, all right, we'll have you come up short to us and we'll talk to you soon. Mr. Ely.
I have Daniel Portillo. He is here and he may need bond conditions.
Wow, he made a surety bond on all those cases.
He did.
Come up, Mr. Portillo. I'm ready to set these for trial. It's 250 days. He's got 5 open cases and they're very serious. What conditions, do you know what the felony court?
I have it pulled up.
Okay, Felicia, this is Mr. Portillo.
Yes, Judge. One form.
What felony conditions do we have, please? Bless you.
You can't go within 200 feet of the 7015 Foray Road, no contact with Jose Cantu and Teresa Portillo Cantu, drug and alcohol testing, travel restricted to remain in Harris County and contiguous counties, no firearms, no.
Do you have a leg monitor on right now?
No, sir.
I'm putting one on you now and I'm giving you a curfew. I don't want you out in the middle of the night. I don't want you to have any weapons and I'm gonna have you sign an affidavit with me today promising me you're not gonna have any weapons. You have with us a disorderly conduct, a discharging a firearm. You have 2 felony assaults, a burglary of a habitation, and now you picked up a failure to ID as a fugitive from justice. Your cases are 250 days old and it's now time to set these for trial. Do you have an offer on these cases?
Oh, look, Your Honor. So
There's not.
there's not, Your Honor.
Counsel, what?
I need you to put one on today. It's 250 days.
Counsel, what
Yes,
bond
Judge.
conditions were you referring to? I don't see any bond conditions. And are you looking at the motion for bond conditions or the file bond conditions? Because I currently don't see anything.
It's 1875107.
Okay.
Order for pretrial.
Absolutely. Okay. Judge, so you would like to match and add a GPS today?
Yeah, and I want to put a curfew,
Yes, Judge.
7 PM to 7 AM.
Seven to five.
Your Honor, he is working in construction from 7 to 5, so.
I'm ready to put these babies to bed. I'm not dealing, I mean, it's just way too much drama for me. Mr. Portillo, we have way too many, so I'd like you to put an offer today.
Yes, Judge.
I want you to speak with your lawyer to see if that's something that you guys, if not, I'm setting your cases for trial today. Do you understand? Take a seat for me, sir.
Judge, would you like to remain in Harris County as well? Yeah.
I have quite a bit of history with Mr. Portillo, not only with the 5 open cases, with other priors that we have had with him. And, so let's see, can you put an offer on the cases? Let's see what you guys want to do and then come back and just let me know.
Okay.
Please.
Armstrong?
And I just got discovery today on the new one, so
250 days.
well, the
you
new one
just got
is, the new one
discovered.
is from December. I mean, there's everybody else.
Okay, I'll give you one reset.
Okay.
I didn't realize that the case is from December. I was looking at the first one where it's from 2023.
I
So,
mean, I was appointed December 19th, so I mean, this is really,
okay, I'll give you a setting.
okay.
Just way too much drama for me and just too much. And it's time for,
He does have, I think, felony on March 12th, so could I do it maybe after that to see, and then if it's done
at that
resolved?
setting, when we come back. I mean, is discovery complete on the failure to ID?
On the fellow ID? Let me see, Your Honor.
I mean, I just talked about it.
Yes, Judge. Discovery is complete on the fellow ID.
Okay.
It looks like there's just 2 videos that need to be shared to you, and we can share those right now.
I mean, are these it?
Because there's also these 2 that just popped up.
Okay,
So, yeah,
okay.
we'll make sure those are shared too.
Mr. Portillo, come up. This is an affidavit that you're going to swear to me today that you're not going to have any possession of any weapons whatsoever for any reasons. If I find that you have a weapon, I can have a contempt hearing, and every time it's punishable by up to 6 months of jail and a $500 fine. Do you understand? I will do everything in my power to protect my county at all costs. Do you understand? I'm giving you 30 days. It is your responsibility between now and then to meet with Mr. Elect. When you come back, you must either accept the plea bargain agreement or your cases will immediately be set for trial. You understand? Come on. Okay, you got it.
I have Mr. Jose Borrego here. He has an assault family member.
Shh. Is this Mr. Borrego?
Yes, correct. And we're asking the court to change or lift the protective order. This is an alleged incident that happened in August of last year. Since then, he and the complaining witness have been co-parenting. She is here right now. It has been very difficult to co-parent because of this protective order in place that they're trying to abide by. He's having to get hotel rooms so that he can have a place to stay. It's difficult with work. Also, she needs help with the child, and this protective order just has been difficult.
If there's a protective order and they're not supposed to be together and they're here together, that's not a good.
They did not come together.
So I don't know anything about your cases. We're going to do probable cause. You have the right to remain silent. All I know is that you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We will do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. The complainant and the defendant are dating, and on August 23rd, 2024, the officer was dispatched to a family assault, and the complainant stated a verbal altercation began while she was in the car. The complainant exited the vehicle with her child, ran towards the home, and the defendant ran after her. The defendant took the baby and put the baby in the car. The defendant then grabbed the complainant's phone and smashed it to the ground. The complainant stated they got back in the car, and the defendant stated he was trying to drive into a box truck to kill them. The complainant grabbed the wheel to stop the defendant, and he bit her left forearm. The defendant began punching her in the face with a closed fist approximately 2 to 3 times. The defendant then stopped at the gas station, dropped the complainant and the child off, and left. The officer observed the complainant had visible injuries to her left forearm consistent with a bite mark, scratches to her face, and bruising on the left portion of her upper right arm.
Guys, I guess, do you want to go do the rip?
Your Honor, we could reach out to our DVD prosecutor.
CW's here.
Yes, Judge, it's also.
That was-
Yes, Judge. So we would need to reach out to the DVD prosecutor to allow him to perform the writ.
Okay, let's do this. The first thing, I want to know what she says, you know,
Okay,
honor her wishes.
of course,
I don't
Judge.
know what her feelings are.
I spoke with her, Judge, and she is in the position, she does not want to go forward with the charges. She wants Mr. Borrego to be in her child's life. Because of this protective order, it's been extremely difficult to co-parent. I spoke with her. I will let the prosecutor speak with her alone.
Is that his biological child?
Correct, yes.
Okay. Mr. Borrego, take a seat for me in the jury box while we get everything done. And then let me wait for the DVD to get here and then we'll get the rip done and then we'll talk.
Okay, thank you, Judge.
You got the rip?
Yes.
Thanks.
So, I understand that there's some issues in terms of child custody and all that. So what I'm willing to do is agree to no threatening or harassing, but keep the residency restriction because they don't live together. And I don't see a reason to allow him to be back at that residence.
He's currently going to hotels and motels so that he can abide by this protective order. It's been a financial strain on him. He's working, hours have been a little short, so it's just becoming increasingly difficult for him to continue to stay out of the residence, away from his child. So I'm asking that the resident.
My concern is the protection of the
Understand.
complaining witness,
Judge,
and
and I will say, I understand that, but given his prior assaultive history, the fact that there's an OR that, allegedly involves another assault after this date, I can't agree to a
I
residency
don't, what are
restriction.
you talking about?
He has 2 TDC trips for ag assaults.
Okay. You're saying there's an assault after this assault?
So I have a note that there was some sort of assault involving the same complainant from October. I'm working on getting the offense report to verify
You know
what
what?
that
I'm not
is.
aware of that, Judge.
So
Come up, Mr. Borrego. Come up. I'm not going to allow a contact if there's a prior assault that you're alleging as well now.
Yes, sir.
95% of the people who are in jail now are there because they have no self-control. They get upset, they wig out, and they do whatever the hell they want to do without thinking, if I do this, what's going to happen? If I say this, what's going to happen? The idea that we have these orders in place are so that nothing else happens. The last thing we want is more mayhem and bloodshed on our streets. I mean, every single day we have someone dying on our streets because of no self-control. They're alleging that there's a prior assault with the same complaining witness. I get it. I know that you say no. I get everybody. What do you think? If I had one strand of hair for every person that said that, I'd have a beautiful head of hair. But I'm here to protect every person in this county at all costs. And they're saying you have this assault now. They're alleging so I don't want any contact. I will let you talk to your lawyer. You guys can hash this out. So hold on. I don't want you to talk here. You guys go out there, take your time. There's no rush. We have a lot of time to work things out. But if I have you charged with assault and they're saying that there's a prior one, it's just not going to happen. I get it. You guys talk, but I don't want you to have contact with this person. Don't. If I find that there's a protective order in place, you have to understand that an assault, you pick up a VPO, a violation of protective order, it's one of the worst cases. We can have a hearing to hold you at no bond when you violate condition on these types of cases. You guys go talk, see what you can do about explaining, but all right, please.
This right here is one of those rare courtroom moments where the law, common sense, and a bit of humanity all collide. Legally, the judge is recognizing a defense of others situation, meaning the teen may have technically broken the law by carrying, but did it to stop an immediate threat. That's huge. But here's the twist. He still gets a warning instead of praise. Why? Because the court isn't just looking at what happened. It's looking at who he's becoming. So let me ask you. Was this justice or just a lucky break?
As of right now, the state wants to we're doing no contact. We're gonna leave the protective order as is. Okay,
I mean, it's
okay. Thank you, Judge.
all right.
Okay.
This isn't absolute. But what I have to know is that you're trying to better yourself. You know, my main concern is that I want you to be a productive person. I want you to work. I want you to work full time because if that's your baby needs food, man. Baby needs clothes. They still eat. The baby needs stuff, you know. My other main concern is that you're alcohol and drug free. And if you can show me that you're productive, that you're working full time, and that there are no issues, we can always revisit it. It's never absolute. But I want to know, look, I don't want to hurt you anymore, you know, but I want you to be the best person you can be. And when you're in that space, that's when you go back because that's when you're the most helpful. Now, when you're all stressed out and all the shices here, I don't want something further to happen. That's it. Okay. So look, it's not absolute. Show me that you're a good person. Show me that you're working, you're alcohol, drug free. Come back and we'll talk. All right.